section that looks at the different deadlines, by when to file, by when renewal fees are payable, by when a case must be granted, and so on and so forth. So any deadlines that are mentioned in this next section are quite important for you to note and to familiarize yourself with. But when we work through the examination papers in our Q&A session, it will hopefully become a bit more real and apparent to you how these deadlines work. Okay, so let's kick off then with the complete applications. So the Patent Act provides for the filing of a patent application that's accompanied by a provisional specification, and it also provides for the filing of a patent application that's accompanied by a complete specification. Now, there are differences between a provisional application and a complete application, in that with a provisional application, there are no vested rights that grant to the applicant of that provisional application. So you don't have any enforceable rights against a third party should there be an infringement of the disclosure in that provisional application, bearing in mind that the disclosure in the provisional application won't ever become a public document unless it is completed. So you file a complete application from that. But the purpose of filing a provisional application is in order to secure your priority dates. So the dates of first filing in respect of that invention. And that is then, as I said, the date that the courts will look at when determining and assessing whether an invention is deemed to be novel and inventive. The reason why you would also file a provisional application, apart from securing that date, is also to allow you a bit of time within which to consider the merits of the application. Some countries, such as England, for instance, do examine the substantive merits of provisional applications. So you can get an indication as to whether the invention that you've described in the provisional specification is novel and inventive. But that's a bit out of the scope of what's necessary for this course. But that option does exist. So you'll file a provisional application. And as I mentioned, in terms of the Paris Convention, you have 12 months within which to file a convention application or a complete application. I refer to those two interchangeably. I refer to it as the Paris Convention or convention application because that timeline is regulated in terms of the Paris Convention, where you have that priority right within which to file an application within a year in different countries. Or as the Act refers to as complete, an application accompanied by a complete specification. So commonly we just refer to it as a complete patent application or complete patent. So, as I said, some of the reasons apart from obtaining the priority right in respect of that invention and to obtain the earliest filing date when filing the provisional application is to then also grant you that 1 year's time before completing the application or filing applications abroad in terms of the Paris Convention to conduct perhaps further market research to determine which jurisdictions you wish to obtain patent rights in. It might allow you the opportunity to gain funding in order to pay for the costs relating to the prosecution of the patents and also to ensure that the product enters the marketplace. So there are various reasons as to why you would file a provisional application. It's not mandatory to file a provisional application. So I just want to make that clear as well. You can bypass the filing of a provisional application and request that an application for a complete application be lodged in first instance. If you follow that route, where you do file a complete specification in the first instance, that date of filing is then considered your priority date. And even from that date, you still have 12 months within which to file in different countries within a 12-year period and claiming priority from the South African complete application. Okay, but this will become a bit clearer to you as we move on. So in many instances, an inventor will approach. Yes, Carl.
Yes, just on the provisional application, is there difference in format or formalities that are required?
Yes,
But does it make it
thanks for
easier
reminding me.
for the provisional?
Yeah, thanks for reminding me of that. So a provisional application doesn't need to be accompanied by a set of claims. And as you'll recall, the claims are what defines the scope of the monopoly and what the courts will look at. So you don't need to include the claims in a provisional application. So you'll still file a specification with your description, the background, um, and as much information as possible relating to that invention. Because when you file your complete specification, complete application must be fairly based on what was disclosed in your provisional application. And in order to have all the matter that you do intend on claiming to have the priority date of that filing of that application. So it is possible as or when you file the complete application to add new subject matter to it, but that new subject matter won't benefit from the priority date of the provisional application. It will be granted the priority date from the date of filing of the complete specification. So that's why it's important to disclose as much as you can relating to that invention in the provisional application to ensure that all the subject matter in your complete benefits from that filing date. Okay. So an inventor will approach you with, as a patent attorney, with some device, some mechanism, something that they feel is considered patentable, which they wish to protect, and you'll advise them accordingly on what the best approach would be. And in most instances, you would file a provisional application. It does show to investors that you are serious about the invention, and it is something you can take to them, having a pending patent application for provisional application to show that you are making steps to to protecting the intellectual property. And I mean, this is something that you'll see in shows like Dragon's Den and Shark Tank. You know, whenever one of the participants in those shows seek funding, they will always highlight whether they have intellectual property protection or not. So it is very valuable to investors knowing that there is some form of protection over IP, or that you're at least making strides in protecting and ensuring that you are the proprietor of that IP. So you can choose to file the provisional application, but I said it's obviously not a mandatory application to file because you can file your complete immediately. But within 12 months, in terms of Section 31(1)(a), and in terms of the Paris Convention, you have to complete that application within a 12-month period. Now, I'm going to look at this from a South African perspective only for the time being. So the provisional application was filed at the South African Patent Office. So it's a South African invention that is filed at the South African Patent Office. And within 12 months, you are required to file a complete application. And it's only from this application that you are granted enforceable rights. So as I said, no enforceable rights arise from a provisional application. You have to complete it. The provisional application only provides you that priority date. But in the instance where the priority application, being a South African provisional application, and you complete it, this 12-month period within which to file is extendable to 15 months. So there is an additional 3-month period that you are able to utilize within which to file your complete specification. But this is only applicable in instances where it is from a South African provisional application that you claim priority from. So that additional 3 months, which you need to request on application to the registrar to grant you that extension of a 3-month period, is only applicable where it is claiming priority from a South African provisional application. So if the provisional application, for instance, was filed in America, in the United States, and you are now filing the complete application in South Africa, that 15-month period is not applicable in that instance. There is only a benefit for those that are claiming priority from a South African provisional application. So please do keep that in mind. It's important to note. And as I said, the prosecution in South Africa is relatively a straightforward process, and grant occurs relatively quickly because of the reason that there is no substantive examination of the application. The Patents Act provides that the application needs to be in order for acceptance within 18 months from the complete filing date. So within 18 months, all the supporting documents to place that application in order for acceptance needs to be submitted. So that would include your proof of assignment of invention, so that the rights have transferred from the inventor to whoever the applicant is, if the applicant is not an inventor. There are additional documents that are required in support of this application, such as the declaration and power of attorney, which is your Form P3. There's also the declaration relating to indigenous biological or traditional genetic material or knowledge, which is your Form P26, that also needs to be lodged in support of this application. And there are other documents that may be required in respect of an invention as well. Your Form P3 and Form P26 is required within 6 months of filing the application, but these deadlines are all extendable upon request. But you do need to know that the application should be in order for acceptance within 18 months from filing the complete application. Again, that deadline is extendable upon request to the registrar. So you can request the registrar to extend that period of time for whatever reasons are necessary for that extension. It might be that you're unable to obtain an inventor's signature for an assignment document, or any other valid reason that the registrar may deem acceptable. So those timelines are extendable, but within 18 months, you should aim to have the application in order for acceptance. Also to note, if the application is not in order for acceptance and no request for an extension of time was submitted to the registrar and it wasn't, or if you did and it was not allowed and it's not in order for acceptance, the application is deemed to have lapsed. So it's basically dead in the water at that stage. This period, as I said, is an 18-month period, but it is extendable by 3 months as of right. So the first 3-month further extension period is granted to the applicant for the invention as of right. So the registrar has to allow that request. Any further extension beyond that does require that good cause is shown. So you need to show to the registrar that you require further time before acceptance, and providing good cause, so valid reasons as to why you are requesting an extension of time. Pius, you have a question? I think you're on mute, Pius.
Oh, sorry, Marco, thanks.
No problem.
So would it be total of 6 months from your provisional application, considering three double months extendable?
So this,
So
the first 3 months, this first 3
Yeah.
months relates to the deadline by which you can file your complete application.
Yes.
Okay, so that's not
So-
linked to this extension. This
okay,
3-month extension is the time by which the patent office needs to issue their notice of acceptance. So the application
Okay,
needs to be in order by that time.
okay,
Okay.
that's fine. Thank you.
Okay, pleasure. Okay, once all the formalities are complied with at this stage and the patent office has examined all the formal requirements relating to the application, they will issue you with an acceptance notice. And the acceptance notice is the Patent Office's stamp of approval that the application is in compliance with the formal requirements of the Patents Act, and that the application may then proceed to grant. The acceptance of the application needs to be published in the Patent Journal within a period of 3 months from the date of acceptance. And this is set out in Regulation 46 of the Act, that the publication needs to occur within a 3-month period. Again, it is possible to request an extension of time within which to publish the acceptance of the application, but again, good cause must be shown for that request. So you'll need to provide reasons as to why you are seeking an extension of the time within which to file the or to publish the acceptance in the Patent Journal. So relatively straightforward prosecution that takes place in South Africa because there's no substantive examination. It's just the formal requirements that need to be complied with in this period. If it's in compliance, the Patent Office will issue the acceptance notice, and the onus is then on the applicant to ensure that the acceptance of the application is published in the Patent Journal within a period of 3 months from the date of acceptance. The process that most firms tend to follow is to publish acceptance as soon as possible, not waiting for that 3-month deadline. The reason being is that the Patent Journal is published on the last Wednesday of every month. So it's 3 calendar months. So you might miss out on the 3rd month's Patent Journal publication date. Another particularly troubling aspect of this is that if the acceptance is not published within the time permitted, within the 3-month period, and there's no request for an extension of time, then the patent has lapsed as well. So imagine all the expenditure of money prior to getting to the stage, all the research development costs involved in filing these applications, prosecuting it, and by missing this deadline, everything is lost in the water in South Africa. So a very critical step from an administrative perspective to ensure that these deadlines are monitored and that publication occurs timeously. Coral, you have a question?
Yes. How do you actually publish this? Is it you send a document to the journal, or what is the actual process of getting it published?
So there is a streamlined process where it's done online via the CIPC's website, where depending on the size of the firm, how many applications there are that you're submitting, if it's a public person that's doing it, just bearing in mind as well that a complete application has to be signed off by a patent attorney. So if you're not a qualified patent attorney, you can't actually file a complete application because it has to be signed off by a patent attorney. A provisional application can be filed by anybody. It is very treacherous to do that, though, and not recommended to do so because, as I said, you must have fair basis in your complete specification on the provisional specification. But going back to your question, when you submit the application, there's a Form P8 that you include in the application. And the Form P8 is basically the bibliographic details that get published into the Patent Journal. And that's also accompanied by an abstract and, if necessary, a publication drawing. So a drawing that relates to the disclosure in that invention. And that's then uploaded, when you file the application, that is then submitted to the Patent Office. But when it gets to that stage where you need to publish, you will again resubmit those details on the specific portal of the CIPC for inclusion in the Patent Journal. Previously, before it was electronic, it used to go to the government printers for inclusion in the Patent Journal. But I'll show you an example of what the publication looks like so that you can see if you're not familiar with it. Okay, then you have your 20-year monopoly that will run from the complete filing date. So your rights are enforceable then from the date of filing of that complete patent application. Again, as I said, you'll see that the monopoly doesn't run from the provisional. It's from your complete application filing date. We have 20 years, provided that you then pay your renewal fees every year. Michael, you have a question?
Hi, Marco. Yes. Sorry, this might be a bit of a silly question. I understand why you might want to delay acceptance. Maybe you want to get formal documents in order, or there's still amendments that need to be done or a correction. Why, generally speaking, would you want to extend the publication deadline beyond that 3-month mark?
A good example would probably have been during the COVID pandemic, for instance, where the patent office was DS non, and then as soon as everyone returned back to the office, all these acceptance notices were issued, and for some it was just too much to process in one go. So these requests were then requested for extensions of the publication dates. There might be reasons as well where the instructing attorney who's instructing the firms themselves to handle the prosecution are waiting for feedback from their clients as to, do they actually want to proceed to grant on this application or not, or do they possibly want to withdraw the acceptance of the application? Because as you'll see later on, when you file a divisional patent application, which is something provided for in Section 37 of the Act, you have the option of filing a divisional application, but you can only do that prior to acceptance. So in that case, you might want to withdraw acceptance as well, pending a client's outcome on their decision.
Okay, so sorry, just to confirm, so normally it is normal standard practice almost to kind of process a withdrawal and delay, a withdrawal of acceptance, go back to almost having the application remain pending in that acceptance phase, then later on. Okay, I'm with you.
Withdrawing, yeah. But it seldom happens in practice, to be honest with you. But there is one or two occasions where there is a need for it. There could also be the possibility that an administrator or somebody handling that acceptance notice never docketed the acceptance date correctly. And so you've already passed, for instance, the second month's patent journal. And if you had to wait for the following month, it would fall just outside of the 3-month period within which to publish, in which case you would then also need to request an extension based on, that administrative oversight, which should be a valid enough reason that it was never docketed for publication.
I'm with you. Thank you.
Okay, pleasure. Okay, so that's a very basic, quite straightforward overview of the prosecution that takes place in South Africa to grant. It is obviously quite more intricate in practice, a lot that can take place during these periods. As I said, a lot of these deadlines can be extended upon request. As I mentioned now, you can also request that the acceptance notice be withdrawn and the deadline be extended again. And the most common reason why applicants would do that is because they would await the prosecution in a corresponding counterpart application in another country where there is substantive examination. So say, for instance, this application for this invention is filed in South Africa and also in the United States where there is examination that takes place. They would prefer to wait to see what happens during the examination of the counterpart application in America and then possibly conform the South African application to be in line with any objections that were raised in America. So if there was any prior art that comes to light in another country where the same invention is prosecuted, applicants will then tend to amend the South African application to overcome those objections here as well, to ensure that at the time of grant there is a valid patent and that there's no prior art that they feel might invalidate the patent in South Africa. And the reason why you would do the amendment before grant as opposed to after is because the requirements are far more onerous to amend a patent application once it has gone to grant. So they'll rather keep the application pending in order to amend it in line with counterpart applications in other countries. Now, if we're looking at the bottom section here, this is following the Paris Convention approach in terms of Article 4, where provisional application was filed, but this would be an application coming from abroad. So where the application for the provisional was filed in the United States, as an example, there's a 12-month period in terms of the Paris Convention within which to file the complete application. This is also applicable in the reverse as well. So if it's a South African that's now filing in America, you would then instruct your foreign attorney, your attorney in the country where you seek to obtain patent protection, to file the application for you on their behalf in that country, but claiming priority from the provisional application. But as I said, this is a non-extendable 12-month period. And then it will follow the prosecution of either South Africa as above, if it's an application entering into South Africa, but if it's an application that's being filed from South Africa abroad, it will then undergo the prosecution of that specific country where it has been filed. Ayas, you have a question for me?
Sorry, Marco. So the publication in the WIPO site is after the first one is after the filing of the complete application. Am I correct? Before the acceptance.
This isn't in relation to a PCT application. So WIPO isn't involved in this. This is purely based on a South African application and a South African complete application. So there's no publication of the South African patent application until 18 months from the provisional filing date. But I'll touch on when the application becomes public as we get to that.
Right. Thank you.
Yeah, pleasure. Michael, you have a question?
Hi, sorry. I just want to jump back to the SA. Just a weird scenario that I was just thinking of. What happens if, let's say, in the event of non-disclosure, so your client hasn't disclosed, and you've basically filed your provisional, and let's say you're kind of edging towards the complete timeline. And let's say your client, I don't know, has come into financial problems or whatever, and they cannot proceed at that stage. Can you also then withdraw? Can you almost scrap the provisional application on record and then basically file at a later stage in the event of non-disclosure?
So there's two options in that event. You can either just allow that application to lapse, the provisional application. It will lapse after 12 months if you don't complete it. So you don't have to take any steps, or you can formally request the patent office to consider that application withdrawn. So you can withdraw the provisional application yourself. If you allow it to lapse, it doesn't become a public document. It remains a secret document, so it won't be disclosed. It's only once it's completed that that provisional application becomes disclosed. But at that stage, if you allow it to lapse, nothing will happen, and you can just refile the application, but you won't be able to claim priority from that application.
I'm with you. Thank you.
Okay. Carl?
Yeah, just to follow up then, when you said you can't claim priority from that the outcome from that is essentially that any prior art that might have come out from a competitor within the last 6 months, that is then prior art that would have been excluded
correct.
if you kept the priority. That's the main drawback.
Yes, that's correct. Yeah. So if you don't complete it within that time, anything will still be considered prior art after that filing date if you don't actually claim that priority.
Sorry, Marco. Why would
Yes.
you consider the South African application route instead of the PCT route?
So number one would be for costs. And it depends on what the target market is and where the market share relating to that invention sits. So if it's a technology where there's more of a global reach in terms of that technology, then you would probably opt for the PCT route, because you are going to nationalize in multiple countries. But where your technology is only related to a very limited scope in terms of where the market share is. So if we had to take something relating to diamond mining, for instance, there's not necessarily use for that technology in many countries in the world. So then you'll opt to rather file directly in terms of a cost-saving exercise, because it's only a handful of applications that you'll be filing.
Now, if I look at this, your diagram, so there are two steps. Is either the South African route, and then the lower one is your Paris Convention. Is that correct?
That's correct, yeah.
Okay, all right, thanks.
Yeah. So yeah, and I'm saying that's also why people often opt to file a provisional application first, is so they can obtain that priority date, but then also to do some market research as to their considerations where they think this technology is relevant, and also to consider their costs. Have they obtained enough funding to file these applications more globally, or are they limited in their selection with where they can file in terms of budget constraints and all of that. So it's purely comes down to those assessments that the clients make, which route they wish to follow. But as I said earlier, the benefit of the PCT is that you obtain a search report and written opinion before entering the national phase in the various countries, where at this stage you'll only get examination reports after you filed the application already. So you would have already paid all the costs relating to the filing of that application. You would have paid costs for the examination in those countries, not just professional fees, but also official fees to the governments where you filed. Okay, so is everyone comfortable with this filing route?
Sorry, Marco, just one question. So if you file provisional, but you do only use the convention route to file foreign, a foreign complete application, does that mean that because your provisional application in South Africa has lapsed, you can still use it to claim priority for your foreign complete, but you cannot use it ever again in South Africa?
So only if you filed those foreign applications within 12 months can you claim that priority. Yeah.
Okay.
But after that period, you won't have any recourse to claiming that priority. No.
One more thing, Marco. So is the total time from filing to grant for S application 24 months, if I count correctly, or is it 18 months?
So ordinarily, what happens is it can be before that even. Grant can occur even within 12 months. And the reason why I'm saying that is because this deadline here, the 18-month deadline, is the applicant's deadline by which to ensure that the application is in order for acceptance. So if they place their application in order for acceptance within 3 months or at the time of filing the application, there's no need for the Patent Office to wait for this 18-month period to pass. They can examine it at the time those documents are all submitted and can issue the acceptance notice at that stage already. So it can happen before 18 months already. And in most of these cases, grant will occur within 12 to 15 months.
So what is the maximum period?
So that's the maximum period. It's difficult to give you a concise answer on that because it depends on the Patent Office's constraints as well. Oftentimes they inundated, they understaffed, they have resource requirements that aren't being met. So there can also be delays in the time that it takes for them to actually issue the acceptance notice. So even though this 18-month deadline, for instance, here by which it should be in order, that doesn't mean that the patent office must accept it at that time. It can be after the fact even, depending on where they are with their internal resources to accept the application. This deadline is more relating to the applicant, that it should be in order within 18 months. But at present, these applications are granted within 12 to 15 months. The maximum, as I said, you can request extensions upon extensions, provided that good cause is shown. So it's dependent on the applicant as well if they require further time to consider counterpart prosecution before the South African application going to grant. So there are cases where an application will be pending for several years before it's granted. But in those cases, it's due to the applicant's intention to permit that. So there isn't a cutoff date per se, but when you are passing this 18-month plus a 3-month request, any request after that, you have to show good cause. So you need to provide the patent office with reasons for the request to extend the deadlines further. I hope that answers you. It was a long answer.
Yes, I got it. Thank you.
Okay, great. So then we'll move on to PCT and national phase applications. So again, we'll start off with a provisional application. As I mentioned, it's not mandatory to file a provisional application. You can file either a complete application in the first instance, or you can even file a PCT application in the first instance. But whatever the priority date is, you need to file your PCT application within 12 months from the provisional application. So you have a 12-month period in terms of Article 4 of the Paris Convention to file a PCT application. So you file the PCT application at the receiving office, which is one of the member countries of the PCT. At that patent office, you'll file the application, and it will then be transmitted to the International Bureau for processing. And you will also designate the country or searching office that you want to conduct the examination for you. So you have the option to select the European Patent Office as your examining country, or the Austrian Patent Office or the Japanese Patent Office to examine the application on the applicant's behalf. They strive to issue you with your international search report and written opinion within a 16-month period from your provisional filing date. Okay, so remember, this is important. It's from the provisional filing date that they aim to issue you with a search report and written opinion. So examination would have taken place of that application for substantive merits on whether it is a patentable invention between the filing and the issuance of that ISR, because the examination is ultimately what leads to the search report and written opinion being issued. And in the search report and written opinion, the examiner will state any prior art that they may or may not have found that is relevant to the invention, which they feel could be a potential to destroy the novelty of the invention or the inventiveness. And they set it out quite nicely in the written opinion by stating that claims 1 to 10 are either novel or not, or they're inventive or not, and are they applicable or not. So you then, as the applicant, can have a good assessment of whether the invention is something that is valid and will eventually be enforceable should an infringement ever arise. Then within 18 months from the priority filing date, so as you can see with the PCT stage, everything goes back to the original filing date of that invention, to the provisional filing date. So within 18 months, the international application, so this PCT application, with the search report and written opinion, the specification, any document submitted in support of the application is then published online. So this then becomes a public document, and that is on WIPO's website, or what's called Patent Scope, where you can then access any international application that has been published. So in the instance where the written opinion that is issued by the examiner is quite a negative opinion, so they find that the claims of the specification are not novel and not inventive, you as the applicant have the opportunity to file a demand. This is an optional step. And with this demand, you'll request that a new set, apologies, that a new set of claims be examined. So you will amend the claims in light of what was issued in the search report and written opinion to overcome any of the objections that were raised by the examiner. And you have the opportunity to file a demand along with an amended set of claims that you wish to have examined. And this is what's known as an Article 34 amendment. At any stage prior to this, you can request an Article 19 amendment, which is an amendment that arises out of the applicant's own accord, that isn't related to the objections of the written opinion and international search report. So you can amend during this international phase, but ordinarily the demand is related to any objection raised by an examiner as to the patentability, and we wish to overcome those objections and to have those claims then examined again. So it's a further examination of a new set of claims that have been filed, excuse me. And then within 28 months from the priority date, if you've requested the demand, you'll be issued with your international preliminary report on patentability. If no demand was requested, so you haven't submitted any amendments to your claims or description, then your ISR and written opinion will be your IPRP. So those two are linked. So an IPRP will issue with after examination of the amended set of claims. But if there's no examination of an amended set of claims, then your ISR and written opinion become the IPRP. So that then issues within 28 months from the priority filing date. And that's basically the end of the international phase. So at this stage, you'll have a very good indication as to whether your invention meets the patentability requirements. Then you are required to enter the national phase in terms of the various countries' laws and to follow their patent application process within either a 30 or 31 month period from the provisional filing date. In terms of Regulation 67DA, South Africa is a 31-month deadline country. And this 30 or 31-month deadline is from the earliest priority date. Okay, so you have to then instruct your attorneys where you are seeking to nationalize this application in their respective countries to please enter the national phase based on this application. So it's the same specification that is filed with those amendments that were made during the international phase will then form part of the national application. Okay, so as I said, for South Africa, please remember it is a 31-month deadline country, and that is then based on national laws. Other countries have a 30-month deadline. For South Africa, that deadline is extendable to 34 months upon request. So you can request that the Patent Office allow the application after the 31-month period, but within 34 months from the provisional application filing date. Okay, so please bear that in mind, that the applicant does have an opportunity to enter the national phase late, provided they request the late entry into national phase be condoned up to a period of 34 months from the earliest priority date. Guys, you have a question?
Marco, sorry to draw you back, just one more. On the
Okay.
South African application, the publication is found where? The publication of the grant, where do you find it?
So that will be in the South African Patent Journal.
Patent Journal, okay.
Yeah,
And then
that's-
okay, yeah.
So,
Patent
and then the
Journal.
international application, this one, yeah, for PCT. The international application is published on Patent Scope, which is WIPO's website.
WIPO.
Okay.
Great stuff.
But then you enter the national phase into South Africa. So South African application is then filed, and once it is accepted, that will get published in the South African Patent Journal as well.
Second one as well is the Article 32 amendment dissenting as a office action.
Could you repeat that for me, please?
The Article 32 amendment, is it dissenting that is called office action? Office. So office action where you yeah.
No, so your and it's just a correction, it's an Article 34 amendment. So that is in response to which you can consider an office action being your ISR and written opinion, should there be any objections. But official actions are issued locally in the national countries, where it undergoes that country's prosecution itself. So it's again examined nationally across the world, wherever you filed, and they will issue official actions should they have any objections regarding the novelty and inventiveness. And then you have an opportunity to amend it, but that's in line with those countries' requirements.
Thank you.
Okay, Carl?
Yeah, I just want to double check. We have the 16 months, 18 months from priority date. That is the date that the provisional application was filed. And it doesn't matter if I file the PCT 6 months or 12 months after the priority date. If I file the PCT application 6 months, I can still go all the way until 30 or 31 months
That's
from
correct.
the priority date. Okay, so
Yeah,
I can get
correct.
24 months extension if I file it after 6 months.
That's correct.
Normally we talk about the 12 months and 18-month extension, but
Yeah,
it's actually, you can get the full 30 or 31.
the full time. That's correct. Yeah.
Okay.
So that time doesn't count from when you filed the PCT application. It's from your provisional filing date. So even if you filed this a month after filing the provisional, it still follows that same timeline. There are instances where applicants seek to obtain grant quickly, and then they'll request that this examination during the international phase be expedited so that the process is sped up. And it's up to them if they want to nationalize before, while in advance of this deadline as well. In South Africa, you can nationalize the PCT application before publication already, but in that instance, you need to request the South African Patent Office to process the application early. So it's an additional application that you need to make in South Africa, but that's a bit beyond the scope of what's required. Yeah, but that does happen. And that's in instances mostly where applicants want to obtain grant quickly to enforce their rights or whatever other valid reason they may have, or invalid reason. Just very importantly to note, when you file a national phase application in South Africa, so it's gone through the international phase and now South Africa is designated and you enter into the national phase in South Africa, the national phase filing date is deemed to be the PCT filing date. So it's this date here. So your 20-year monopoly for a national phase application runs from this international filing date and not the national phase date. Okay, so please remember that, everyone. It's important to note your renewal fees as well for South African applications that come from a PCT and are nationalized from a PCT is from the PCT filing date. That's deemed to be the filing date in South Africa. Okay. When it comes to any formalities in South Africa, it will be based on the national phase filing date. But for all other purposes, your international filing date is deemed your filing date. So where the monopoly runs from, when the rights are enforceable from once it's granted, and where renewal fees are calculated from. Okay, I hope everyone is comfortable and familiar with the two major processes that one can follow in obtaining patent rights. There was a lady that, sorry, I can't recall her name now, but that asked this morning as well about how you would obtain these rights, and I hope this answers your question about
Yes,
the
it
various
does.
countries. Okay, thanks, Lebo.
So sorry, Marco. So the 20 years grant we count from when?
From your PCT filing date.
But it has not been granted by then.
So once it's granted, the rights, your monopoly is based from that date. Okay.
All right.
Okay, so I hope everyone is comfortable with that and familiar with the respective processes in terms of the Paris Convention that you can follow, or the PCT and national phase applications. Those are the two types of applications that are dealt with mostly. In South Africa, most applications that are filed in South Africa are national phase applications that have gone via the PCT international route. But then if we just look at some of the paperwork, the regulations, the forms that need to be submitted, as I said, not the most riveting work, but you do need to be familiar with this, is that in terms of section 31, it says an application for a patent may be made in the prescribed manner and on payments of the prescribed fee, and shall be accompanied by a provisional specification or by a complete specification. So this just says that an application may be filed, but you need to pay your official fees, and that it must be accompanied by the provisional specification or a complete specification. Then read with Regulation 22, that application is made on Form P1, that is for a provisional or complete application in terms of the Paris Convention on Form P1. And it must also be accompanied by Form P2. And Form P2 is basically sets out all the bibliographic details relating to that application. So it will have the priority application filing date, the priority application number. It will have the inventor's names, who the applicant is, or if there is more than one applicant, who the applicants are, their addresses. So basic information that is then required to form part of the patent register. Then, as I said earlier, you are required to submit a declaration and power of attorney on Form P3, an assignment or other proof of the right of the applicant to apply for the application, a provisional specification on Form P6, so that is your cover page to the specification for provisional application, is a Form P6, and for a complete specification, your cover page is a Form P7. Then it must be accompanied by drawings, if there are any drawings, and also an abstract or publication drawing that's accompanying the P8. Yes, Carl.
In terms of the proof of the right of the applicant, would that, I mean, if I'm applying now, would that just be an affidavit where I state, I mean, if there's no assignment or anything, how would I have proved the right to apply?
Yeah, so I think I do touch on this a little bit later on, but we can touch on it briefly now. So there's various forms that you can prove that you are entitled to that invention. The most common being that there was an assignment that took place, which is a contractual agreement between two parties. In most instances, being an inventor that has developed or devised the invention, and where the inventor is transferring that right to a third party. So that's basically a purchase and sale agreement. It's a contractual agreement, a deed of assignment, where the rights are transferred from the inventor to a third party. And even if there's a third party that sells it onto another party, you would need to show that as well. So that entire chain of who's actually filing for the application, you need to show that those rights transferred. So that's one instance where there's a deed of assignment. A lot of cases, in a lot of instances, these transfer of rights arise out of operation of law. So where the law regulates that relationship between an employer and employee, for instance, where the employee is an inventor and in their course and scope of work with the employer, they have developed the invention, then that invention automatically belongs to the employer. And that is set out in various countries' legislation. So the UK Patents Act in Section 9 provides for that. And there's a few others in Germany and across the world where there is this operation of law. In terms of common law as well, it's believed in South Africa that the rights are transferred from the employee to the employer. But again, the Act does require that you provide proof of this. So what proof would suffice in that instance? An employment contract would likely be acceptable. So where you can see that the inventor is employed by the applicant. If the employment contract provides for the assignment of intellectual property rights as well, that will be acceptable. Even if you consider the relationship between researchers at universities and university students, most of their contracts with the university provide for the assignment of intellectual property rights. So any proof that will satisfy the registrar that there has been a transfer of rights to the applicant will be sufficient. And those are just some of the few that I can think off the top of my head that will be acceptable. Good. Okay. Then in addition to those forms, since December 2007, it was also a requirement that a Form P26 be lodged with an application, as you can see there from Section 33A and Regulation 22(1)(EA). And that is a statement that either attests that the invention is or is not related to or derived from indigenous biological resources, genetic resource, or traditional knowledge or use. So if it is a South African indigenous or biological or genetic resource or material, then additional requirements need to be complied with in order for those rights to be granted. But if not, then the application will proceed to acceptance, or if you state that the invention is not related to any of those. Yeah, I mean, this arose, due to the protection of traditional knowledge and resources, positive stride. Every application in South Africa needs to be accompanied by P26. So it doesn't matter whether it's a mechanical invention or biological invention. All applications need to have a Form P26 declaration stating whether or not it is a biological, natural, genetic, or traditional resource, knowledge or use thereof. I think this probably arose from, if you think about the Hoodia case or the Hoodia matter. So the Hoodia plant was being used by the Khoisan in the Kalahari as an appetite suppressant. They used to, during times of drought or such, chew on the plant, which would be used as an appetite suppressant to stay off any of the hunger pains or feelings that they might have experienced. And this was then something that the CSIR picked up on, and they had extracted the compounds from the Hoodia plant that was responsible for this, and probably benefited quite substantially from that, as the processing of that compound into a pharmaceutical for weight loss management or appetite suppressants. That was a burgeoning market for appetite suppressants, and they probably benefited immensely financially from that. And that is something that this strives to protect, is that where it is traditional use or knowledge, that those communities benefit from it, as you'll see from Regulation 33B. So if the invention is related to any of the aforesaid, then the applicant needs to provide a permit issued in terms of the National Environmental Management and Biodiversity Act, that they are actually allowed to use the material, that there is prior consent obtained in terms of NEMBA, that there is a material transfer agreement in place, and that importantly, there's a benefit sharing agreement. So the community that has this knowledge housed within their community are able to benefit from that. So a trust should be set up for that community, for example, so that they do have just reward from something that they had identified, or possibly a co-ownership over that invention, so that they can share in the profit and advantages that accrue by virtue of the patent rights. And then any other proof that the registrar may require that relates to that invention. Then again, Regulation 23 provides that an assignment or other proof to the satisfaction of the registrar of the applicant's right to claim priority. So it does happen in instances where the priority application is filed in one company's name, and then when it's time to complete it, it is now in the ownership of another company's name. Then you need to show that the rights to that priority application have also been transferred to the applicant for the complete application, so that they actually have the rights to the priority application itself and not just the invention. So that's a requirement in terms of Regulation 23. And this is why I say that that complete chain of entitlement from the inventors up to who the final applicant is when filing the application, you need to show how those rights have all transferred from the inventors to the respective steps in that chain. Again, I'm going to go through this quite briefly because a lot of this we have touched on already. Regulation 24 states that if you are claiming priority from a provisional application, then this is in a South African context where you have a South African provisional application, then the Form P2 of that prior application needs to accompany the complete specification. So Regulation 24 is solely relating to a South African complete that claims South African priority. Then it's not necessary to submit a certified priority document, as you can see in Regulation 25. So in Regulation 25, if the priority application is a foreign application, then you need to submit a certified priority document. So that is basically the application that was submitted in the country, in the foreign country. And if it isn't in a language other than one of the South African official languages, then a translation of that document is also required. Then importantly, section 32 also says that every application shall contain an address for service, and this is set out in the Form P3. So with every application, we now know that a Form P3, which is a power of attorney and declaration, needs to be submitted with the application. You'll see when we touch on the grounds of revocation tomorrow that the Form P3 is a very important document because of the declarations included therein. One of which being that the applicant is not aware of any invalidities in the invention. So you can revoke a patent based on a false declaration made on the Form P3. So a very important document to be aware of is the Form P3. And you'll see from last year, I actually included a Form P3 in the examination paper and asked for any irregularities that you may have picked up on that form. So do familiarize yourself with it, but we'll touch on it in the Q&A session as well. Okay, that's fine. Section 35.5, you can have a look at. The minimum filing requirements, again, quite self-explanatory. You can read through this on your own time. Just so that you are aware, you can make an amendment to the priority details if you deem necessary within a period of 2 months. Then looking at the form of an application for national phase application, as you can see, these are amendments to the Act by the nature of the nomenclature of the sections there. So basically providing that an application may enter the national phase within 31 months with an extension of a 3-month period, provided that the prescribed fees are paid, so the official fee. Who knows what the official fee is to file a patent application? Anyone? How much does it cost to pay the government for an application? Michael?
I think it's 590 Rand.
That's it. Yeah, so 590. So that's what's payable to the patent office. It's incredibly cheap if you ask me, if you see what official fees across the world are. And that fee hasn't changed for decades. So it is time that it's revised, hopefully. Then if the international application is not in English, a translation of that application also needs to be submitted. The translation can be in any official language of South Africa, but in most instances, it will always be a translation into English. Okay. As you'll remember, an application for provisional or a complete application is made on Form P1, but for a national phase application, it's made on a Form P25. So there are just some alterations to the form that cater for additional details that are included in the application form that stem from a PCT application. Okay, I think let's break for 5 minutes here, if that's okay, just for a comfort break. Just going to grab some water as well quickly, and then we can continue on to the next section regarding priority claims. Are there any questions on the subject matter we've covered now? Okay, no. Let's reconvene then at 2:20, everyone. Thank you. Welcome back, everyone. We can kick off where we left off last. So just bear with. Apologies for the interruption, everyone. Okay, so section 31 of the Act provides for the various applications that we can claim priority from. So first off, in section 31A, you can claim priority from an application accompanied by a provisional specification. And this is, in my interpretation, relating to an application that was filed in South Africa, a provisional application that was filed in South Africa that you now wish to complete. So you are able to claim priority from the South African provisional application. Then the second option is that you are able to claim priority from a prior application accompanied by a complete specification that does not claim any priority. So you can claim priority from a complete application where that application itself was the first application in respect of that invention. So the complete application itself has no priority claim. It is, however, possible to claim priority from multiple applications itself, provided that it is all within the 12-month period within which to file from the earliest priority date. So always from the earliest priority date. Then you are also able to claim an application from a convention country application, provided that in claiming priority in terms of A or B, so the two that we've already touched on, was lodged not earlier than 1 year before, or on payment of the prescribed fee not earlier than 15 months before the date of the application of claiming priority. So this refers to the instance where you are filing the South African complete application that claims priority from a South African provisional application. You are able to file that application within 15 months as opposed to 12 months as is otherwise provided for option C, where you're claiming priority from a convention country. When also provided in claiming priority in terms of paragraph C, the application in the convention country was lodged not earlier than 1 year before the application and was the first application in any convention country in respect of the relevant invention. So that's the standard 12-month period within which to claim priority from an application. Then the applicant in the application claiming priority is the proprietor of the prior application or has acquired the right to claim priority in the Republic. So if the priority applicants and the South African applicants are different, you have to show why that difference exists. So there must have been an assignment of those priority rights so that you are actually, in fact, able to claim priority from the prior filed convention application. Then very importantly, the application from which priority is claimed must be the first application for the subject matter in that country. An issue often arises from the United States where they will file continuation applications and continuation in part applications, which is applicable to the United States. And this is not for examination purposes, it's just for your information. And they will add new subject matter, which is similar to our patent of addition in South Africa. A new subject matter is added and they then claim priority from a later filed application. But when you look at the history of that application, it in fact has prior priority application dates that fall outside of the 12-month period. which could be potentially problematic in the South African application. But don't be too concerned about that. That's what we commonly refer to as the Benz situation. And I will touch on this a little bit later on when we look at acceptance. But if there had been an earlier application, and this touches on the question that you asked about earlier, Michael, where a provisional application is not completed, what do you do in those instances? So then the prior application must have been withdrawn, abandoned, refused, without it becoming open to public inspection. So if you are claiming priority from a subsequently filed application in respect of that invention, then you must make sure that there are no rights outstanding on that first application, by either ensuring that that case was formally withdrawn or it was abandoned by not actually completing it. Then what should be contained in the specification itself? And this is set out in section 32 of the Act. It says every specification shall indicate whether it is a provisional or complete specification, and shall commence with a title sufficiently indicating the subject matter of the relevant invention. So you'll indicate that it's a provisional or complete specification by either submitting a Form P6 for provisional application, the cover page for provisional, or Form P7 for a complete specification. This requirement is not applicable to national phase applications, where you need to indicate a distinction between the two. Then a provisional specification shall fairly describe the invention, so you need to provide as much information in that provisional specification in order for there to be basis for the complete specification from that provisional specification. So over and above the specification that you would have with the provisional specification, and a complete specification will need to have an abstract that details or gives a brief overview of what the invention relates to. This is limited in terms of the regulations to 150 words. But this complete specification must sufficiently describe, ascertain, and where necessary, illustrate or exemplify the invention and the manner in which it is to be performed in order to enable the invention to be performed by a person skilled in the art of such invention. This is a very important provision in terms of section 32, because when we look at the grounds of revocation tomorrow in section 61, if this requirement is not met, where the invention has not been sufficiently described or does not allow for persons skilled in the art to perform that invention, then the patent may be revoked on the ground that it is inutile and is insufficiently described. So as you can see, if this requirement is not met in section 32, then the patent can be revoked on that ground. Then, as Carl asked this morning, the difference between a provisional and complete, the major difference being that a complete specification must be ended with claims or set of claims that define the invention for which protection is claimed. Then section 32(4) mentions that the claim shall relate to a single invention. It shall be clear and shall be fairly based on matter disclosed in the specification. What's very interesting here is that in terms of this section, an application for patent can relate to one invention only, but it often does arise where there are multiple inventions that are claimed in a specification. But in terms of South African law, it's not a ground to attack the patent on. So even if there are multiple inventions disclosed in the specification, it's not a ground for the revocation of the patent. And there's actually no recourse that a third party has should they wish to pursue any remedy against a specification comprising more than one invention. The problem arises, and it is probably arguable, that the scope of protection is not very clear, that what is it that you're claiming in your invention, because there's multiple inventions that have been disclosed in the document. So what is it that the patentee is actually claiming? What is the scope of the monopoly? And this might not be seen favorably by the courts, because there isn't clarity in the claims themselves. But that's something that's never been tested by the courts, and it'll be interesting to see should that ever arise. But in instances when this does happen, there is the option to file a divisional patent application, which basically splits the application up into its separate inventions. But I'll touch on that as we get to that stage or topic where we discuss divisional applications. Okay, section 33. A lot of what we have discussed and what you know already, just that the priority date of the invention will be the date of lodging of the earliest of such prior application in which the matter was disclosed, insofar as it's fairly based on the earliest application. And then in determining whether an invention claimed in an application is fairly based on the matter disclosed in the prior application or prior application in a convention country, regard shall be had to the disclosures contained in all documents lodged at the same time in support of the prior application. So if ever there needs to be an assessment of whether complete is based on what is disclosed in the priority document, it mentions that all the documents lodged in terms of that priority document need to be assessed in making that assessment. Then again, as I said, you are able to claim more than one priority. So this happens where new subject matter might be added to the invention. So further developments are made and you file an additional provisional application where that additional subject matter is contained. Then you can claim priority from that provisional application as well. We then turn to section 38. Section 38 provides for the conversion of a complete application into a provisional application, and also for a complete application to be post-dated. So if we have a look at section 38.1, it states that the registrar, on request by the applicant, may at any time before the acceptance of the specification. So important to note that this request must be done before the application is accepted, but not later than 12 months from the date on which the application was lodged at the patent office. That complete application may be converted to a provisional application. And this might be necessary where an applicant requires a bit more time to consider the invention and then possibly later on to complete it themselves. So they're not ready for that document to become a public document. You can convert a complete to a provisional application, but just bearing in mind that any provisional application that you claim priority from must still be a valid priority claim should you later complete it. Then, before the acceptance of a complete specification, the registrar may also post-date a complete application to such dates as is requested, provided that the application is not post-dated to a date later than 6 months from the date it was actually lodged. So you can't request that it be post-dated to a date beyond 6 months from its actual filing date. And also, if that application does claim priority, it may not be post-dated to a date later than the last date on which that application could have actually been filed. So if you do post-date it, you should still have a valid priority claim. So the filing dates, the post-dated filing date, must not extend beyond 12 months from the earliest priority date. And then there should also be no rights left outstanding. So that means that whatever rights relating to that application should not have lapsed or become abandoned or become void, particularly in light of any priority claim in respect of that invention. By post-dating an application, it also allows the applicant additional time for putting his application in order. It also increases the length of the term of the application, which may be granted on the application, but it is risky because the applicant takes a chance that there could be an intervening novelty destroying intervention. So where there is some prior art that comes to light from the post between the filing and the actual post-filing date. And there's also not certainty as to whether certain countries will consider that post-dated filing date as a recognizable filing date from which you can claim priority from. This is quite a bit to digest, so do please go through it again on your own time and make sure that you understand by when these actions can take place. Then just a bit more on the procedural aspects. Section 34 and Regulation 40 of the Act does provide for the examination of a provisional specification, but it says that the provisional specification is examined only to ensure that the documents are legible and capable of reproduction. So there's no formal examination or any substantive examination that takes place. But for regular complete application, it does state that the registrar shall examine every application for a patent and every complete specification accompanying that application. And if it complies with those formal requirements, it shall accept it. Section 34 is just what I touched on now, is that the registrar must examine an application for its requirements in terms of the Act. Again, Regulation 41 is relating again to the documents, the forms, the abstracts, microbiological deposits that are required to be submitted with the application. You can have a look at that. Again, Regulation 42 for self-study, basically that the applicant can remedy any defect that the registrar brings to light or to the attention of the applicant by way of an official action. The applicant has 3 months within which to respond to any official action issued by the registrar. So if there is a document missing or outstanding and the registrar calls for the applicant to submit that document, they need to comply within 3 months or as such time is allowed upon request. If no response is received and there's no request for an extension of time, then the application is deemed to have lapsed or abandoned by the patent or by the applicant. Okay, that's not necessary. Section 40, you'll recall this deals with the lapsing of applications, where when we looked at the first slide relating to the filing process for a complete application, that an application must be in compliance for acceptance within 18 months from the filing date. That 18 months is reduced for national phase applications. So for national phase application, it needs to be in order for acceptance within 12 months of the South African filing date. If it's not in compliance with acceptance and there's no request for an extension of those acceptance deadlines, then the application is deemed to have lapsed unless the applicant files an appeal to the registrar. Also, if the application is not accepted at that time and it is as to no part of the applicant, but it's due to administrative delays or the patent office's delays, then the application is also not lapsed. It's just to allow the Patent Office time to accept the application. As I said, that first 3 months of the acceptance deadline is granted as of right. So if you request the first 3-month extension after the 18 or 12-month extension, it has to be granted. But any further request for an extension of that acceptance deadline by which to place the application in order, valid reasons are required. So the true reasons as to why you're requesting that extension must be provided to the registrar. Then Regulation 44. As soon as the registrar is satisfied that an application complies with the Act, and unless there has been a request to delay acceptance, he may accept the application and give written notice thereof with Form P8. So the Patent Office then returns the Form P8 in a stamped form together with an acceptance notice stating that the application complies with the formal requirements of the Act, and the application may then proceed to grant. This is also in line with Section 42(1) that says when the application accepted, the registrar shall give written notice to the applicant, and that is in the form of an acceptance notice. Just for your information, the acceptance date is included in the notice of acceptance, and also that a statement that on publication of acceptance in the Patent Journal, the patent is deemed to be sealed and granted. So once the acceptance of the application is published in the Patent Journal, that is the date that the rights become enforceable. So the rights are granted to the patentee from the date of publication in the Patent Journal. And as I previously mentioned, the acceptance needs to be published within 3 months from the date of acceptance in terms of Regulation 46, but that is extendable upon request to the registrar. If that request was not allowed or no request was made and no publication occurs, then the application is deemed to have lapsed. This is just an example for you to have a look at of what the acceptance notice basically looks like that's issued by the Patent Office. They have moved away now from issuing these in hard copy form, and the acceptance notices are now mostly issued electronically, so they are sent to the applicants via email to then process and to arrange for publication in the acceptance journal. Are there any questions? Diakanyo? Diakanyo? You're on mute at the moment. I'm not too sure where Diakanyo is. Diakanyo, if there are difficulties with the microphone, perhaps you can send your question in the chat and I'll take it from there. Okay, so if we look at some case law that relates to the acceptances of an application and the deadlines by which to publish, a very important case in practice is the University of Pretoria versus the Registrar of Patents case. In this case held that if at the date when acceptance of the patent application is due and there's no request for an extension of the acceptance period and the patent is not in order for acceptance, then the patent application lapses. So this is basically a rehash of what the Act already states, so that if publication does not occur timeously, sorry, not publication, the extension periods itself for acceptance. So if the application is not in order for acceptance by the 18-month deadline, and there's been no further request for an extension of that period, then the application is deemed to have lapsed. But problematically was that this case held that there's no possibility of extending that period for acceptance further after that date has passed. So if that acceptance date has passed, let's work on the 18-month period that the Act prescribes. If that 18-month has passed and the request to extend that period was not made before the deadline of that 18-month period, then the application has also lapsed. And this was held in the University of Pretoria case to be the case because of the peremptory wording of Section 40 that says the application shall lapse. But then also turning to Section 42.3, the wording is also peremptory, and the court also had to look on this matter where the acceptance notice was published out of time in the patent journal. And the court said that unless acceptance of the patent application is published within the prescribed period of 3 months, the application shall also lapse. And this case also held that it's not possible for the registrar to extend that publication period if the request was not made prior to the expiry of the 3-month period and good cause shown. So if the acceptance notice is not published within the period of 3 months, or if it is published after the 3-month period, but there was no request for an extension, or if it was not published and also no request for an extension, then the application is deemed to have lapsed. And the case held that it's not possible to make that request for the extension after that 3-month period is up. So you have to make these requests be prior to the expiry of the deadlines. So either the acceptance deadline of 18 months to extend the acceptance deadline, or when it comes to publication of acceptance before expiry of the 3 months from the date of publication. So the University of Pretoria versus the Registrar of Patents case touched on 2 matters where it looked at both the acceptance deadline by which a case should be in order for acceptance, but it also looked at the publication of acceptance period. So a very important case to please be aware of and to have a look at. But very interestingly then, and this was a matter that I was involved in, was the Mu Mechanicos case versus the Registrar of Patents. And this was a case, Spoor & Fisher did not prosecute this application. It was filed and prosecuted by another South African agent. And the patentee had then requested that the file be transferred to Spoor & Fisher to handle the patent further should there ever be any renewal fee due on the patent or such, for us to monitor that. And when I actually perused that file, I had noticed that the acceptance of the application was not published timeously. So it was published outside of the 3-month period. And as you can imagine, upon my advice to the client, I'd informed them that their application had actually lapsed due to the non-publication of the acceptance in the patent journal. And also upon further inspection, I noticed that no extension had been requested for the publication deadline. The client was obviously not happy about the situation and had asked for any remedies. My advice being solely on what the Act provides and what was found to be the law at the time by the University of Pretoria versus the registrar case, what the law stated. That is the advice that was given to the client. But in that instance, the client had then requested that we do try and revive the application in some form. So a request was then made to the Registrar of Patents to post facto allow an extension of time for the late publication of acceptance in the patent journal. And the patent office or the Registrar of Patents had refused the application, also citing the University of Pretoria versus the Registrar of Patents matter. And as you can see, this is set out in the slide here. So you'll see that the application was accepted on 30 June 2021, and the publication of acceptance occurred on 27 October 2021. So that's outside of the 3-month period, July, August, September, because they would have had to have published acceptance by the end of September. So then, on the instruction from the client, the request for an extension of time was filed on 3 May 2023. Bearing in mind that this case was transferred to me around that time. Then on the 10th of May, the request was submitted to the registrar and the application refused. And that is the response that we received from the registrar at the time, that according to the University of Pretoria versus the Registrar of Patents, the preemptory language of section 42.3 and regulation 46 has the following implications, and that is that the request for an extension of the period of publication must be made before the expiry of the 3-month period. Good cause must be shown and the prescribed fee must be paid. And that application was then refused. So in terms of the Bone SA and Mu Mechanicos judgments, the Mu Mechanicos judgment being the case that I was involved in, the late publication of the acceptance of a patent application without any application for an extension of the deadline for publication results in the lapsing of the application. And that's very clear from the Act. But what's debatable is whether that extension may be made after the expiry of that deadline. So if we then move on, the clients had then instructed the previous attorneys that were initially responsible for publication to appeal the registrar's decision. So application was then made to the Commissioner of Patents of the Court of the Commission of Patents to overturn the registrar's decision. And the decision was overturned by the registrar. So if we look at what I've mentioned in the slide, it says, however, subsequent to that lapsing, it is possible to obtain an extension of time for the publication of acceptance at the discretion of the registrar, provided that good cause is shown and the prescribed fees paid to rectify the lapsing of the application. So this is where the Mu Mechanicos case differs from the University of Pretoria case, in that the University of Pretoria case held that the request for the extension of time must be made before the expiry of that time. However, this was overturned in the Mu Mechanicos case, where they said that the request may be made after the expiry of that time, provided that there is good cause shown. So it does provide a bit of clarity where the publication of acceptance occurred after the 3-month deadline and an application for extension was subsequently filed to the expiry of that date. And in terms of this judgment, they confirm that the registrar has the discretion in terms of 16.2 of the Act to grant an application for an extension of time where such application is made after the deadline. I don't know if I necessarily agree with the judgment. Because there are quite severe implications if that request is allowed. If you consider the third party public, because at the time, if a third party had to look at the application or the register page and acceptance was published out of time and that there was no extension requested, that third party might deem the application to have lapsed, and it would have lapsed. And they might then start utilizing that invention. But what happens now in the case where this request to extend the publication is filed after the expiry of that deadline? There's no clear guidance by when this request, there's no specific time limit that's prescribed in the judgment by when this request should be made, even after expiry of the deadline to publish. And then all of a sudden the application and the patent are revived again. That could be very prejudicial towards a third party that has already started using that invention, because now all of a sudden where a patent or an application has lapsed, there now exists a granted patent with the patentee having enforceable rights against any infringing party. So it's an interesting one to debate. Are there any thoughts on this?
I'm just thinking. Now I'm not 100% sure, but if you have done this, would not there be some remedy similar to, I think, maybe trademarks, where if you've done something before somebody registered, then they would not be able to enforce those rights, because at the time that you were doing this, you were not in breach of their rights.
Yeah, I actually don't know, and I'm not aware of any remedy. There's nothing expressly provided for in the Act or any case law on this. If you have a look at the restoration of a lapsed patent, so where renewal fees is missed unintentionally and the patent is restored, in those instances, the rights of the patentee are limited. And I feel the same type of provisions should apply in this instance, where the rights of the patentee are limited, so that any third party who did start using that invention won't be considered an infringer. But it's a difficult one, and I guess we won't know until this is ever adjudicated on by the courts or the legislation amended to make provision for such instances. The other thing is, why stipulate these express deadlines in the Act when a request can be made at any time? It just seems a bit bizarre to me. Okay, so two important cases to note, especially the Mu Mechanicals case, considering that this was judgment came out last year, so very relevant case law and very relevant in practice as well. Dekanyo, your question is that what happens if the application gets accepted before the documents are lodged? So there are instances where an official at the patent office might accept an application prematurely, and that is because they may have overlooked that there are outstanding documents on the file, so they haven't properly examined the application formally. So there could be that there's an assignment missing or P3 assignment missing. In those instances, we'll normally liaise directly with the patent office to advise them that we believe the application was accepted prematurely because whatever document is still outstanding. So then they will rectify the register in that regard. And normally so in terms of section 52, which provides for the registrar to rectify the register. So it's basically a case of returning the acceptance notice to the patent office, and they then sort it out from their end. Is everyone still fine to continue? Can hear my voice is becoming very croaky and hoarse, but we'll try keep going then. I don't think there's too much left of this section, so let's, yeah. Okay, I think we'll stop at corrections and amendments. So let's continue then on with when an application becomes open to public inspection. So in terms of section 43.1 to section 43.3, the patent and the application and all documents lodged in support of the application become open to public inspection at the patent office, either after grant or publication of the acceptance in the patent journal, and the priority document, so the provisional applications document, will then also become open to public inspection at the same time. And that is where the this is a South African application that is claiming priority from a South African provisional application. So it will only become open to public inspection once the application is granted. So just consider the various scenarios here. So this is a situation where the South African application claims a South African priority application. It only becomes a publicly available document. The file only becomes open to public inspection once that application is granted in the Patent Journal. But if an application has a foreign priority claim, so it's a South African complete application via the Paris Convention, but it claims priority from a foreign priority application, then the file becomes open to public inspection within 18 months of the earliest priority date. Okay, so there's different timelines when these documents become, or when these files become available to the public, and it forms part of the state of the art at that stage. For national phase applications, the Act is silent on it, but in terms of the PCT, those publications of the international application become publicly available documents upon publication during the international phase, which is also 18 months roundabout from the earliest priority date. Okay, so normally when a national phase application is filed, that file at the Patent Office is already a public document. Okay, section 43 for A and C, you can have a look at that in your own time. Section 44 goes on to the sealing and grant of the patent. So it says that the patent is to be sealed, i.e. be granted as soon as practicable after publication. So this is when the letters patent document is issued, so the actual patent certificate. I showed that to you earlier, what the patent certificate looks like. With that patent certificate is annexed the specification, the register page, and any amendments that were made during the prosecution of the application. Then the patent has effect from the date of application. But very importantly, in terms of section 44, there is a moratorium on when the patentee can institute infringement proceedings. So the patentee can only institute infringement proceedings against a third party if they believe their patent is being infringed after 9 months from the date of grant of the patent itself. So there's a 9-month period from which a further timeline is calculated. So no infringement proceedings may be issued within a 9-month period from the date of grant by the patentee. However, this can be condoned upon request to the commissioner, but good cause needs to be shown to the commissioner as to why you're seeking to institute infringement proceedings straight away.
Sorry, Marco, why this? Why 9 months from grant? What is the reason for this?
I don't know why expressly they selected 9 months, but my thinking would be so that the public has the opportunity to become aware of any grant of a patent, so that they do have time to be notified of the existence of the patent, so that they can conduct their own searches in the Patent Journal to see whether the rights have granted or not. So I think it's just to give the public a fair opportunity, should they possibly have been conducting any work on that invention, to stop performing any of that work. That's the only logical reason that I can think of. And then this is basically just an example of the electronically issued Patent Journal. So the image on the left being the cover page of the Patent Journal, and then on the right you can see are the details of the granted patent. So this is the acceptance that's then published in the Patent Journal, and which seals the date of grant. So this patent, 2015 04457, would have granted on 31 May 2017, and that was then applied for on 19 June 2015 by the Procter & Gamble company, the names of the inventors, the priority details. So this claim priority from a US application, which was filed on 7 January 2013. Then the title of the invention, an abstract that's accompanied by a drawing. And the abstract and this drawing are mostly used for searching purposes. So if ever you're conducting a search to determine whether your client's invention might possibly infringe, if there is an invention relating to your client's invention, you'll search through all the patent office records to determine if there is something relevant as prior art, and that will then give you an indication what that invention relates to. Hi, Carl.
Sorry, just to clarify here, this invention in this case, or in this example, the 20-year monopoly that you have on this is from the 1st of July 2013, or how's it? Is it American dates there?
I'm just trying to see, this could have been a national phase application. So that's a priority date. It would be from 19 June. Wait, it's quite strange because this doesn't have an international filing date, which is very important. Give me one moment. Let me quickly check this one up on the register. That's a very good point you make. I'm just having a look at the register on CIPC's website to have a closer look at those dates. Because this, I suspect, is a national phase patent from a PCT. So then the 20 years would be from the international filing date.
And not the priority date that the international one
Yeah.
is claim priority from.
No. Okay. Can you see this register page?
Yes.
Okay, so
But could you zoom in
let's
slightly?
see. It's quite a delay. There we go. That better?
Yes.
Okay. So if we have a look at this application, it is an international filing date. So you can see over here, international application, and that is the PCT. That's the international applications filing date over there. And that was filed on 6 January 2014. So the 20-year monopoly would run from that date. But the national phase was entered on 19 June 2015, which is that date over there. And it claims priority from that application. So 7 January 2013. So you can see from the earliest priority date, which is the same date over there from that US application, the PCT was filed 1 day before expiry of the 12-month period, because that was filed 7 January 2013. So they had until 7 January 2014 within which to file the PCT application. Okay, so they filed it a day before that 12-month period was up, the international phase application. And then this application would have been nationalized before 31 months from that date. Okay, let's see. And this, for your interest, this patent has lapsed as well because the renewal fees haven't been paid. So you can see only 2 renewal fees were paid on this application. But we'll touch on renewal fees a little later on. But yeah, it's interesting to see that the patent journal doesn't actually include that international filing date, which is a bit odd. That's something that I will take up. It could be this is quite an old publication itself, so maybe it has been updated. But I'll look into that. Okay, then we'll move on to patents of addition, which I did mention previously, which is something that's when I was speaking about the Benz issue and what the Americans like to do where they add new matter to applications. South African law also provides for the filing of a patent of addition. And a patent of addition may be filed at any time in respect of the parent patent. So this is where you already have filed a patent application at the South African Patent Office, or you have a granted South African patent, and you now wish to add new subject matter to that invention, then you can file a patent of addition, provided it is in respect of that same was related to that subject matter. So if we have a look at section 39, it says where a patent for an invention has been applied for or granted, and the applicant or the patentee applies in the prescribed manner for a further patent in respect of any addition to, improvement, or modification of the invention described in the claimed or claimed in the complete specification of the main invention, he may be granted a patent of addition. So this is where, as I said, you have already filed an application for a patent or have a granted patent, but you have made a modification or have added new matter to it or have made improvements to the already filed application or patent for an invention, and you now wish to protect that improvement or modification or addition, then you can protect it by way of a patent of addition. And this may be filed at any time during the life of the patent. The period of that additional subject matter for which it is protected is running for the same time as that of the parent patent. So any new subject matter that is included in the patent of addition will expire when the parent patent expires. So it's not 20 years from the filing dates of the patent of addition, it's 20 years from the filing date of the parent patent that new subject matter is covered for as well. So it doesn't extend the life of the patent miraculously. Okay, so the life of the patent of addition will be the same as the life of the parent. They run the same course. But on the instance, the applicant or patentee may request that the main patent or main application be surrendered or revoked, then the patent of addition becomes the main patent. I'm not too certain why you would do that, because there are no renewal fees that are payable on a patent of addition, so long as the main parent is active. But in the instance where the patent for the main invention is surrendered, revoked, refused, or abandoned, the patent of addition shall become an independent patent, and the normal term of such independent patent shall not extend beyond the expiry dates of the main patent for the main invention. As I said, there are no renewal fees payable on a patent of addition unless the patent of addition becomes the main patent or main application, then renewal fees are payable. But just to then also look further at section 39, it also says that the grant of a patent of addition shall be conclusive evidence that the invention is proper subject matter for the invention and shall not be refused, nor shall any patent be liable to be revoked or invalidated on the ground that the invention claimed in the complete specification does not involve an inventive step. So you can't attack a patent on addition on the ground that it does not involve an inventive step, because it is related to the same subject matter of the main patent. So any new matter added there, you can't invalidate it based on it not involving an inventive step where the main patent is then considered prior art. Also, interestingly, these are basically tied at the hip or joined at the hip, so you can't deal with the patent of addition separately to the parent patent. So if you are assigning the main patent, you also need to assign the patent of addition to a third party, if that is the case. Pius, you have a question?
Thanks, Marco. What would be the incent motivation for patent of addition?
So it would be in instances where the proprietor has has made an improvement to that invention itself. So it's related to the invention of the main patent, and they have either made some modification to it that they wish to protect. But it could be that that modification may not necessarily meet the novelty requirements, as an example. No, sorry, that's actually hogwash that I'm saying, but it is linked to the invention that was already disclosed, but that there is a modification that they now wish to protect. So instead of going through the whole application process and possibly the prior application being considered prior art, you can then have this extension by way of a patent of addition. Yes, Carl?
Is this also the case where with your modifications or additions, your new invention is now no longer covered by the claims of your main patent, and then you want to extend that? So can this patent of addition then have new claims that then would explicitly cover your new
Yeah. So
invention?
The patent of addition will have new claims specifically looking at those improvements to what was prior disclosed in the main invention. So it's got separate claims to that of the main invention, but with that modification to it.
And you can also make modifications to the description so that it can be covered in the claims.
Yes, that's right.
Okay.
Okay. Then you'll recall I mentioned divisional applications in terms of section 37. These are just the various types of applications that we're going through that you need to be aware of. So apart from the provisional and complete and national phase applications, there's also the patents of additions and divisional applications. So where there is a unity of invention problem, and that is where the disclosure in the specification relates to more than one invention, you do have the option to file a divisional application, which is basically where the one application is split out into the respective inventions. So if the application discloses two inventions, you can then file a divisional application that focuses on one aspect of the invention, and the main patent then amended to look only at one of the inventions that was originally disclosed. So it's a splitting up of the disclosure in the original patent document. But a divisional application must be filed before the main invention becomes accepted. So if you have lodged an application, you have to file a divisional application before that parent application is accepted at the patent office. So if we have a look at section 37, it provides that where at any time after an application has been lodged at the patent office and before it is accepted, a fresh application is made in the prescribed manner by the same applicant in respect of parts of the matter disclosed in the first mentioned application. The registrar may, on application made to him before the application is accepted, direct that such application be antedated to a date not earlier than the date on which the first mentioned application was so lodged. So quite a bit more to digest. But essentially, you will file a divisional application before the originally filed application is accepted. But in that application, you need to request that the divisional application be antedated so that the filing date is an antedated filing date to that of what the parent application is. And this is in order for you to still have valid priority claims in respect of the matter that's disclosed in the divisional application. So even though the divisional application may be filed today, the effective filing date is the antedated filing date. So the date of the parent application originally filed. Okay. But a patent granted on such fresh application shall not be revoked or invalidated on the ground that the invention claimed in such application is not new. So the disclosure in the parent application is not considered prior art in terms of novelty against the divisional application, which only makes sense. And those are the only requirements that the Patent Act provides for in terms of divisional patent applications. There was a case that touched on divisional applications, and that's the Pharmadynamics versus Bayer case, where the Supreme Court of Appeals held that the claims of a divisional application must not be coterminous. And what they mean by that is that the claims must not be the same as the parent. So there must be differences in the claims between the parent application and the divisional application. There can be overlap of these, and the divisional's claims can be broader in their scope than that of the parent application. But importantly, the claims cannot be the same. So they must be directed towards different subject matter or different inventions that were disclosed. So in this instance, when you file a divisional application, the specification or the description will in all instances be identical to what was originally filed, but the claims will differ because you're directing the scope of monopoly to different aspects of the inventions. Okay. Everyone happy with that? Okay. I hope I'm not losing you. I know it's getting late now and it's a lot to take in. Okay, then if we look at the term of a patent, we all know that it's now 20 years from the filing date, bearing in mind that the filing date differs between the types of applications. If it's a convention application, a Paris Convention application, it's the date of filing at the South African Patent Office. But if it's a national phase application, it's 20 years from the international filing date. Then in order to maintain your patent rights to ensure that the rights remain enforceable, you do need to pay your renewal fees. And in terms of section 46.2, your renewal fees are due from the third year of filing the application. So this again differs between Paris Convention applications or complete applications and PCT applications. So the 3-year period from when renewal fees are calculated, so your base date from which renewal fees are calculated, will either be from the South African filing date for convention applications or complete applications, or it will be calculated from the international phase filing date for national phase applications. But this slide here, in terms of section 46.2, relates expressly to ordinary patent application. So it's either a complete or a convention application. And it says that a patent shall lapse at the end of the period of the period prescribed for the payment of any prescribed renewal fee, if it is not paid within that period, provided that the registrar may, upon application and subject to the payment of such additional fees as prescribed, extend the period of payment for any such fee for a period not exceeding 6 months. So if, apologies. So the renewal fee is due, the first renewal fee due is due within 3 years from the application filing date. So if we have a look at this application being filed on 10 June 2000, 3 years from that period, the first renewal fee was due. So on 10 June 2023, the first renewal fee was due. However, Section 46(2) provides for a 6-month grace period up to year within which to file or to make payment for that first renewal fee. So any renewal fee that is due on an application, you have 6 months within which to pay that renewal fee. So there is a 6-month grace period from the expiry dates of when that renewal fee was due to pay the renewal fee. Yeah, everyone happy? So first renewal fee is due within 3 years. If that deadline is missed, you do have a 6-month grace period within which to pay the renewal fee.
But you must apply for that grace period. It's not automatic.
Yeah, so you have no, it's not automatic. So you have to request on the form itself. It has an option for late fines. So you basically just pay the late fines, and it's allowed. Okay, but in instances, if we look at Regulation 46, where grant occurs more than 3 years from the application date, so grant has taken quite a bit of time to occur, then the first renewal fee is due on grant. Okay, so very important to note that. So if we have a look at the application date, 3 years has already passed, but the application is not yet granted. But it then proceeds to grant, and the first renewal fee was already due. The first renewal fee was already due whilst the application was pending. Then you need to ensure that that renewal fee is paid upon grant. Okay, so any outstanding renewal fees that would have ordinarily become due during the pendency of the application then fall due once the application grows to grant. Then if we have a look at Regulation 67, this is only applicable in instances of national phase applications. Again, very worded and very confusing, but I'll try my best to break it down for you. It says that if a patent issues on an application filed in terms of Section 43, so that's a national phase application, 3 months or more before the expiration of the 36 months from the international filing date, Regulation 48 shall apply. So in that instance, if during this period before the expiry of 36 months, the patent, 3 months or more, so if the application proceeds to grant within 33 months of the international filing date, then any renewal fees that were due are payable. Sorry, I'm confusing myself here now. Yeah, so those renewal fees will then basically fall due as they ordinarily would have. So if the application proceeds to grant within 33 months from the international filing date, those renewal fees fall due ordinarily. So when the first anniversary occurs, that renewal fee is payable. But if the patent grants more than 3 years after the international filing date, so anything after 33 months, considering the wording of Regulation 67I2, it says less than 3 months prior to such expiration date. So anything that grants after 33 months from the international filing date is provided a 1-year grace period. So you basically provided the grace period in terms of Section 46(2). So when that renewal fee is due, plus in terms of this regulation, an additional grace period within which to pay that renewal fee. So when it comes to national phase applications, these due dates are slightly a bit more complicated, considering these deadlines. But yes, I believe that covers or the renewal fees then, and the differences between them. So do you need me to recap this?
Yes, please.
It's just, okay, so we'll recap this for good measure. So if a national phase application proceeds to grant within 33 months of the international filing date, then the renewal fees will fall due as they ordinarily would have. So at the 36-month date, the first renewal fee is payable, and the 6-month grace period is also applicable in that instance. But in the instance where a national phase application proceeds to grant after 33 months from the international filing date, then the applicant or patentee is provided an additional 1-year grace period from that date when it was due to pay the renewal fee.
Thank you.
Pleasure. And this timeline basically just sets those variations out for you to have a look at. And that then brings us to the end of today. Are there any questions on the subject matter that we've covered so far that you'd like to discuss before we close off? Okay, if there are no questions, then if you do have any questions tomorrow morning, please do ask them before we start off on the next section of corrections and amendments. And I do hope that you will all return, that I haven't scared you away, and that patent law isn't something that I've made you more afraid of. It is quite a monster to overcome. Very intricate, a lot of differences, nuances to the law in patents to be familiar with, and I think quite a information overload for today. But I do appreciate your attendance, the time you've taken out of your day to attend. And as I said, I am available should you have any questions. But with that, I wish you a good afternoon, and I hope to see you tomorrow morning at 9 o'clock again. Thanks, everyone.
Thank you.
Thank you.
Thanks,
Thank you.
Marcus. See you
Thank
tomorrow.
you.
Thanks.
Thanks, Marco.